Hello everyone, this is Robert Mansour. I'm a lawyer in the Los Angeles area, and this video is designed primarily to help my clients. During the final meeting I have with my clients, I usually go over a lot of the frequent questions about handling their living trust and handling their estate plan in general. And so this video is designed with those questions in mind and really mimics the information that is available in the overview section of the binder. In your estate planning binder, you'll have an overview section, and in that section is much of what we're going to discuss right now. The reason I created this video is another helpful tool for you that you can watch on occasion to make sure that you're doing things right and you're handling your estate plan properly. So the title of this presentation is, I have an estate plan, now what? And again, all my contact information is right here. My phone number is 661-414-7100, and my website is mansourlaw.com. So let's dive into the material. Some clients, during that meeting, they're like, oh my God, this is a lot of information. I don't want to read all these documents. And I tell them the good news is you don't have to read all the documents. Really, you should focus on the overview section of your estate planning binder, and that's the very first tab, essentially, in your binder. And I think that as of this recording, the review section or the overview section is about 7 pages long, and you really only need to be concerned about the first 3 pages, 3 or 4 pages. The rest is designed for your successor trustee, and that would be the person to handle matters after you have passed away. Watch this video from time to time. I know you don't want to read all these documents. There is a summary near the end of your overview section, near the back, which is a section-by-section review of your living trust, as well as a review of some of the other documents in your binder. And that is a summary that is found near the back of the overview section. I decided to create a page on my website that is not available from the regular menu. It's www.mansourlaw.com/clients. And this is where I have this video, and I plan to add other helpful material as well as the years go on. Make sure you keep Schedule A current. Near the very end of your living trust is a document called Schedule A, and that's where you're going to list all of the assets that are in your living trust. It's important to list all the assets that are in your trust on this schedule. And so if you take a look at the very back of your trust, that's where you'll usually find it. There is a practical reason for listing all the assets that are in your trust, all the real estate, all the bank accounts, etc. And the practical reason is that so your successor trustees don't have to try to figure out what was in your trust. It's all right there listed for them. There is also a legal reason why the schedule is important to keep, and that legal reason is because if an asset is forgotten and you forgot to put it in your trust, the mere fact that it is listed on your schedule is enough for many judges to just go ahead and order your asset into the trust. So let's say you forgot an asset and it never made it into your trust. I can go to court with a special petition and ask the judge for an order ordering that asset into your trust, and therefore we can still avoid the probate process. I still have to go to court, but at the very least it's a shortcut and a way to backdoor an asset into the trust simply because it was listed on Schedule A. Of course, you want to keep that schedule current, take a look at it every few years. Another question I often get about the estate plan is, what if I want to leave certain items of personal property to people? Well, near the very end of your living trust section, you will find some sheets that are entitled Instructions for Distribution of Personal Property, or something like that. And that's where you would write down with specificity who you want to get what. So for example, you can say, my diamond bracelet that I received on my 25th anniversary to my cousin Sally, so-and-so, Sally Smith. So you want to make sure you give those things away with specificity, and then your successor trustees are in charge of distributing those specific assets to specific people And that's how you do that. And of course, if you change your mind, you can just start a new sheet, and you really should date the the document when you sign it. It's important that you show your intention. Some people even take photographs of the items and write down who they want them to go to, as long as it's clear. Now remember, you must put assets in your living trust, and I say it because you might remember during the meeting I usually draw a big circle and I say, this is your trust, and I start putting things in the circle, inside the circle. And it's important to take the time to do that. You can't just think about it. You can't just go home and have dreams about putting your assets. Nothing is happening here by magic, folks. You actually have to take the time and the effort to go ahead and put those assets in the trust, which means that you have to visit the banks where your accounts are. For example, some people say, well, what should I put in my trust? And this is a common list of assets: checking accounts, savings accounts, CDs, investment accounts, stocks, bonds, credit union accounts, real estate, etc. Now, usually I take care of the real estate for my clients if there is any real estate to take care of during the signing meeting. So you might recall signing a couple of deeds or one or two deeds, depending on the amount of property you had. And then usually I give the clients some instructions about how to put the rest of their assets in the trust. And so here is a list of assets on this particular slide that represent the most common types of assets you should try to put in your trust. Some people say, well, why should I even bother putting assets in my trust? Isn't it enough that I listed them on my Schedule A? And the answer is no. Schedule A is a nice backup to have, and it's important to have that backup, but I wouldn't rest on that. I would take the time to take a look at all my assets and decide which ones need to go in my trust, and I need to make the effort to do that, which means I have to go to the bank, show them my estate planning binder, show them the language that I gave you during our final meeting about how to put your asset in the trust. So that leads to the next question. How do I put my assets in my trust? How does that happen? Well, you need to use special language. So you can't just, once again, just kind of, put your mind to it, or just think about it and things will magically occur. You have to actually use special language. So for example, for a single person, the title to his assets might read, Joe Smith, trustee of the Joe Smith Trust, dated March 14, 2011. And that's an example for a single person. That's how their bank accounts would read, their real estate, their CDs. Remember, you have to change title to those assets, and by doing so, you are putting the asset in the trust. A married couple might read Joe Smith and Mary Smith, trustees of the Smith Family Trust, dated March 14, 2011. This is another example of how title would read to the asset if you were putting it in the trust. So for example, if you go and take a look at my real estate, you're going to find that it has my wife and my name, trustees of the Mansour Family Trust, dated, etc., etc. So it doesn't have just my name, it actually has the name of the trust. Therefore, it is now in my trust. Now when you go to the bank and you try to put these assets in the trust, they might ask you for the certification of trust. And the certification of trust is in your binder, and it's a special tab and it says certification of trust. Some places call it an abstract of trust. Some facilities will actually have their own form. Frankly, I really don't care. Just do whatever is needed to get that asset in the trust. Now, there are three main benefits that we've discussed before about putting your assets in the trust. The number one benefit is that anything in the trust avoids the court system. The number two benefit is that anything in the trust can be managed by your successor trustees, the people that you've chosen in advance. And the third main benefit is that anything in your trust is governed by your trust. So if you've got something sitting outside your trust, in your name alone or owned jointly with somebody else, that asset doesn't necessarily have the same benefit and is not going to necessarily be governed by your living trust. Now, some assets do not go in your trust. Some assets will pass through a different funnel, usually by way of a named beneficiary. So these are different kinds of assets. So what are we talking about here? We're talking primarily about tax-deferred accounts, IRAs, 401ks, 403bs, pension plans, annuities, etc. These types of assets generally pass by way of a beneficiary. Now, people say, well, what beneficiary should I put? In most cases, I'm a fan of naming people, individuals who are going to benefit and be your beneficiaries. And the way you do that is you have to ask the company for a beneficiary form. Again, it doesn't happen by magic. You actually have to take the effort to fill out the form, give it to the company telling them who you want your beneficiaries to be. Now, if one of the beneficiaries is your children or a child, you have to ask the question of the company, what happens if my child passes away? So let's say you have two kids, Sally and Michael, and you want to make sure that each one gets 50-50. That's fine. But you have to ask yourself, what if Michael were to pass away? Do Michael's kids get his 50% share, or does it all go to his sister Sally? And when it goes to the next tier of children, the grandchildren if you will, that is known by the following magic language called per stirpes, which is the Latin phrase, which is equivalent to by right of representation. And on some of these beneficiary forms, you might have a box that you can check that says by right of representation, or per stirpes, or it might just simply be the company's policy to do so. So you have to ask the company, what do they do if a child dies? And you have to ask yourself, am I okay with what they do? And if not, then maybe you have to write in the words per stirpes or by right of representation, or you may have to choose a different company, or you may just have to live with it and keep your eye on the beneficiaries, because if one of them were to pass away, you might have to revisit the beneficiary form and make sure that it's updated. Again, this is the kind of thing you should take a look at every few years. Now, in some cases, you can name your living trust as the beneficiary of your IRA, your 401k. You don't always have to name individuals. However, I would only do so if you have significant concerns about how your beneficiaries would handle the asset. If you think they're just going to blow it and they're going to do something stupid with it, then I would name your living trust as the beneficiary of that particular asset. But these are different kinds of assets, and they generally pass through a different funnel, and that funnel is called the beneficiary funnel. Now, your living trust does not need its own tax ID number. This is another issue that seems to come up after somebody creates an estate plan. They go to the bank and they want to put things in their trust, and the customer service person says, well, I need your tax ID number for the trust. And some banks will ask for this, like I said, but in some cases your trust will need its own tax ID number, but usually not until you or your spouse passes away. So you can tell the person at the bank that your trust is a revocable trust, if that is indeed the case, and in most of my clients they have revocable trusts, and you just tell them a revocable trust does not have its own tax ID number until it becomes irrevocable. And that happens after one spouse or both spouses pass away. Not always when one spouse passes away. You have to take a look at what kind of trust you have, and it depends on the circumstances. But while you or your spouse are both alive, you don't really need to worry about that at all. Use your own social security number just as you did before you created the trust. Now, some people say during the meeting, what about my vehicles? What should I do with my cars? Should I put them in my trust? And the answer is not necessary in most cases. In most cases, it's not worth all the effort. The DMV, the Department of Motor Vehicles, has their own procedure in the event that somebody passes away. They have their own procedure about how they get the car to you. If the cars are the only things that are not in the trust, you're going to be fine. And you just fill out some special forms with the DMV. You have to wait a certain number of days after the death, and then you can get your hands on the vehicle. If you are the successor trustee, then you would probably be the one to act on this procedure. If you purchase vehicles in the future, it might be a good idea to put them in the name of your trust if you want those assets to be governed by your trust. Some folks ask about what to do with respect to home insurance, and my advice is generally that, adding your trust as an additional insured to your homeowner's insurance, all you really need to do is call your insurance broker or your insurance company for your homeowner's policy and ask them if you need to add your living trust as an additional insured to the homeowner's insurance policy. The answer is either going to be yes or no. In most cases, it's not necessary, but some companies like to do that, and in most cases, there is no fee. They just basically add the trust, and they're going to want the name of it and the date, etc., and they will add it as an additional insured to the homeowner's insurance policy. The next question I often get is people say, well, what if I want to make changes to my trust or to my other estate planning documents? And I always tell them, look, there are formalities to making changes, okay? Because I'm not a big fan of making changes by hand. I've had clients, I've seen them write in the margins of the documents. Again, I suppose that you are really changing your document by doing so, but that's not the proper procedure for doing so. So if you want to make changes to your documents, the best thing to do is to just do it in the formal manner, and an attorney should be able to help you with that. After I file the deed with the county recorder's office to put the real estate in the name of the trust, sometimes my clients get this thing in the mail called a declaration of homestead. And they call me and they ask me about that. They say, do I really need to file this? Is it important? Should I worry about it? What this does is it protects a portion of your home's equity from creditors and judgments. So, there was a time when this was kind of important. It doesn't protect your home from mortgage companies coming and taking your house if you default. So if you don't make your mortgage payment, your mortgage company can just come and take your house. That is a secured asset. So this doesn't really help you there. So what I usually tell folks is it's probably not necessary to worry about this unless you think you will be in trouble with creditors in the future. If you anticipate owing a lot of people a lot of money, then maybe it might be worth filing this document. But otherwise, it's not really that big of a deal. What about life insurance, people ask? What should I do about that? In most cases, I advise clients to name their living trust as the beneficiary of their life insurance if they want their trust to govern the distribution of the life insurance money. So if you want all of your life insurance money to go to your brother Tom, well, you got to name Tom. But if you want the money from the life insurance policy to be distributed according to your living trust, I would go ahead and make the living trust the beneficiary of, the life insurance policy the beneficiary. Oh no, actually I said that right. I would go ahead and make the living trust the beneficiary of your life insurance policy. How do you do that? You get a beneficiary designation form from the life insurance company. You just call them and say, hey, life insurance company, I want a beneficiary designation form because I want my living trust to be the beneficiary. But again, you can name anyone you want. You can even name percentages. You have 50% to so-and-so and 50% to so-and-so. Just keep in mind that minors should not be beneficiaries of the life insurance policy, especially if you don't want them accessing that money right away. If you have a minor, they can't access that money until they're adults. Currently, the law in California is a child is an adult at the age of 18, so they would have access to all the life insurance money, which would not be a good idea in all likelihood. It's probably better to have that money managed for the minors. So that's another reason to name your living trust as the beneficiary of the life insurance policy. Some people ask me, they say, well, where should I keep this binder? You will receive a binder from my office in most cases if you've done an estate plan with me. And this binder should be kept in a safe place. I wouldn't put it in your safe deposit box or in your safe, a combination lock safe at home. What good is it going to be if your loved ones cannot get access to those documents? It's like having a toolbox that you can't even open. So just make sure you put it in a safe place and make sure you tell your team where it is. So the people that you've chosen as your successors, your trustees, your agents for power of attorney and healthcare, and your executors, everybody should know where this binder is. Don't keep it a secret. My office generally keeps a copy of the documents, but the originals are the best. And in many cases you will be asked to produce the original documents, not simply copies. Another common question that people ask me is what we should do, or what they should do, with their advance healthcare directive. Remember, this is the document that allows people to make healthcare decisions for you. With this particular document, I say give a copy to your agents. The people that you've named in your document, give them a copy. Tell them to put it in their glove compartment in their car. In case they have to rush to the hospital, they have a copy of it right then and there. Another thing that some people do, especially elderly folks, they'll put a copy of the document on their refrigerator or on the front door of their home so that emergency personnel will find it. And emergency personnel are often taught to look for the healthcare directive on the refrigerator or behind the front door, on the interior of the front door, I should say. So that might be a good place to keep it. You can also give a copy to your doctors if you have some regular doctors that you go to, or you have a hospital nearby that you're most likely going to be taken to if something were to happen. Maybe they already have a file open for you. You can add your healthcare directive to that file. And you just mail them a copy and say, please keep this with my records. After somebody dies, things need to be done, but not right away. And this is very important because a lot of clients kind of freak out and they don't know what to do when somebody passes away. Keep in mind, there are rarely any emergencies. There is rarely anything needs to be done immediately. You can order some death certificates, but even that doesn't need to be done right away. Usually the mortuary will help you with that, and they will ask you how many death certificates you need. But I always tell people to get professional guidance after somebody dies, because you want to make sure that you're handling the affairs of your loved ones properly. I wouldn't start distributing assets right away. This is another thing people start to do. They start giving stuff away, and they start moving money from one account to another, and sometimes they are actually doing more harm than good. And this is very important. Sometimes people go into action mode after somebody passes away, and they do it because they feel like they have to be doing something, and they don't want to sit at home and grieve all day, so they put themselves in action mode. And when they're in action mode, I think sometimes they do more harm to the estate. And it's a good idea to get some professional guidance, especially after a few weeks after the person has passed away. Also, some married couples have living trusts that require a split of the trust assets. This is another reason to kind of calm down and take stock and not do things in a knee-jerk reaction. Some people have a disclaimer trust. If you worked with my office, you may have one of these kinds of trusts. A disclaimer trust means that the surviving spouse is allowed to disclaim certain assets, and those assets would end up in a sub-trust, usually called the decedent's trust. Some people have an AB trust, and an AB trust is similar, except it is a required split. So once again, you can imagine that professional guidance would be a good idea instead of going into action mode and starting to, move things around and distribute money. At the very least, here I put, a consultation is prudent. Then the final question people have for me is they say, well, what about the successor trustee? How can we help them? What can we do? So this slide says, I'm the successor trustee. What should I be doing? Remember, the successor trustee takes over after the trustees, both of them or one of them, whoever created the trust, has passed away. In the binder, I usually put a detailed checklist of things to do after someone dies. So take a look at that. It's usually part of the overview section, so review that. Also, check out some other videos on this website, in this particular page, and in the rest of the website that might be helpful. I've tried to create a lot of different videos to assist clients in as many ways as I can. And again, a consultation with a lawyer is a good idea if you're the successor trustee. If at the very least to kind of create a game plan, which is a very good idea as to how you're going to attack this particular estate and what assets you're gonna handle and in what order. Also, the successor trustee could give some of that work to the lawyer and say, look, I'll do this part, and you, Mr. Lawyer, you do the other part. So they can work together. So thank you very much for watching this video. I hope you found it helpful. It's less than 30 minutes, and hopefully it had some good ideas for you. If you have any questions, you can call my office at 661-414-7100, or you can visit my website, which is mansourlaw.com, for more information as the years go on. Also, remember, mansourlaw.com/clients is a place where I'm going to keep additional videos over the years. So hopefully you found this to be somewhat helpful, in addition to the information that we discovered, or that we discussed rather, during our signing meeting. And also you will find that most of the information that I've presented in this presentation is similar to the information that you will find in the overview section of your binder. But these are the very top questions that I receive time and time again. I want to thank you all again. My name is Robert Mansour, and I appreciate you watching this video. Take care.